because, my lords, there are, in the two answers, there are a number of different things that are referred to. I'm actually not clear.
The issue is determined as the preliminary objection. That has been set out as read by the President of the Court.
Well, perhaps we could hear it again because it was not...
Is whether or not the petition discloses any reasonable cause of action. That's it. Please, we will instruct the registrar to type the orders by the close of the day, and they will be served on you. Because it's case management, you have to be fully informed of the orders.
My Lord, with respect, this is case management, and I believe we have an input that we can also make as parties. Because we had, for instance, witness statements, is it by tomorrow? I mean, my Lord, with the greatest respect, I mean, we are human. I mean, maybe they're superhumans, you know, but we have filed this morning. As of this morning, we have filed an application for review of a ruling that you delivered yesterday. There are consequences to that. We also have outstanding requests to admit facts, which are due within 3 days from when they were served on the other parties. There are a number of outstanding issues which have not been discussed.
There's no outstanding issue. The application for review of our ruling yesterday does not operate as a stay of execution.
Well, I do not, with respect,
we are operating on strict timelines under CI 99.
The notice to admit.
Yes, but my Lord, it can affect the issues. In fact, your lordships will recall that yesterday, when we were discussing the filing of the issues, we raised the point that the matter of the interrogatories and the notice to admit facts could affect the issues that we filed. There are some issues that we may not actually require.
If you get there, can't you apply for these issues to be taken as additional issues?
Yes, but in the meantime, we would have filed witness statements, which are limited to...
Call 5 witnesses. I believe you should know what you're going to say. As at the time you were indicating that you were going to call 5 witnesses.
Yes, so we are going to have 1 day within which to supply witness statements in respect of 5 witnesses. Is that... I think that with respect is not fair to us, because with the greatest respect, we have indicated that we have 5 witnesses. We may end up not calling all 5 witnesses. But in any case, we have now, today, until tomorrow, in order to prepare witness statements.
Mr. Kikata, this should have been prepared already. These statements should have been prepared already.
Well, that is not correct. Maybe your lordship,
Mr. Kikata, excuse me. Mr. Yene, please resume your seat, sir. Please, you are a senior member of the court. When the bench engages counsel, you don't sit down and make gestures as if you are part of the legal team. I've been watching you. Please, this is not fair. You see, the other time we heard you clear when an objection was taken, when the representations were announced. I even asked Mr. Kikata whether they were limiting themselves to the only 2 counsel. Mr. Kikata, I think you remember the very day. And you said you were with only Mr. Luther. And you were recorded as such. But Mr. Yene, please, out of respect for you, please don't do that again.
Mr. Chikata, if you recall, we've gone through the regimes of CI 87, we've gone through the regimes of even witness statements in criminal matters, and so where we've arrived at now in administration of justice and case management is preparing everything up front, and I'm sure you're quite aware of that.
I'm aware also of the fact that it is a matter which parties may make representations about. That is a matter of whether it is conducted through witness statements or through oral testimony. I mean, that is also a matter to be considered on the basis of representations made. But, I mean, your lordships have made the orders already, and we will be served with them, and I believe we will advise ourselves. But I do feel obliged to indicate that the timeline that is provided for us to have witness statements, does not seem to be justified.
But Mr. Chikata, you know about CI 99 and its schedule. That's the 2016 law.
I do know about the schedule provided, but I also know that your lordships are here to administer justice, and that justice must not be sacrificed for expedition.
The petition is hereby adjourned to Tuesday, the 26th of January 2021 for hearing.
We are grateful to the court. Resume your seat, please. Lord, we are most grateful.
This is Angel 102.9, broadcasting live from the capital city, Accra. Angel 102.9.
The Diacoso Yana Pitri, and then Oma Pijo Muntem, and the answer be Pija Muntem. Answer the Yabacono, Chairman can say, said the agronity, and I you Grandami and San, I said Nanai. You're the better answer for you to me, panel, a Supreme Court for the review. Chachu Chikata, a filing on behalf of the petitioner. Yeah, His Excellency John Mahama. Chuma Mitrika Krebi, Ecoso, our home. Layamo is Ampa Beba, on one of them. Said the course on the table. Watch the match on one year, friend, on one year, friend. And then the whole what to me actually need their chair. Former Deputy Attorney General, so we can one President of the Supreme Court say no. What you warn you to soon be no catch and say more yebium. Hey, me you no pack a chamin co. Yeah, catch and just see him say Tuesday number Saba. Nti
as in the next sitting.
The next sitting. Echina ya wada Supreme Court entrance. Eye fiada on entrance. Ejuada Supreme Court entrance. Supreme Court entrance e brada. Enti e brada ena yebesa toa so sa. Enti echina de e be pon ye 10 no pepepe. Na yensu yakọ ne yakọ home. Na efiada nso say nanka principal, head teacher.
Oh, say COVID na course quarantine school no cry.
Oh, say your school no yembie. Back ya bobo ya ho pa. Eti lawyer Morris Ampa ba wi a na afei yetimi ehu no. Kwame mindim se bia na wo judges na adwunu mu na odi hu se here be 2 days bia.
Who say uhunu wo chachu new fairness application or the akoto say electoral first respondent electoral commission and provided certain original documents of form 9 from 10 11 12 19 13 yeah there enti ohwemu a let us say afa na o say e ko serve omo lawyers no with that application because they all demand if you want to just almost office ekoye hu aduma no mo koye yes a copies de nyina no mo be present because osu hia e de ma court no na court no so e de ama chachu any any team of lawyers as I said no those requests no especially those forms near there no is of substantial value to the substantive case omo edi ho asem. I don't think say fair says documents the only thing what's application the request for original, as I keep saying this, the request for original instead of being the request of copies of the original. There are two things. Open copy, open original so there and also one matter that is also different from it. And kind of Morris now Sisuma Madrian crack also indeed that's the case. Then you must be requesting for the original copies. And the original copies there and I even photocopy crana. We have to go and do it in the office. So we need some days. Yes. To say a moment days. Oman Kasa Kwamle said within 3 days the people must provide them with those documents requested for.
Tuesday.
And you be here. Initially, almost person more so nice. I said, night year, Rachachuna and in your home said, I didn't know air con case and no chemisiano pay or filing a dear. Yamo person or filing, and I think no more request and Yama be Nina, why and I say, Munchi is a Munchi, dear, and ask someone I say. I say you are not being fair to him, near dear. But in the name of which we said debut. Now next sitting won't mean provide and I won't mean resist us some nana and
yeah, court Supreme Court back na Braco Ewo a Honafe said Aquacusino Untima Yen Timubi. Ama say what's a menka at Traswa Homae. Hello, Ama, what's a menka?
Check so that you don't push something before again.
Yeah, hello.
All right. Let's go.
I'm a braconte antiminka. Yakona Chamakasa.
Let me conclude on the number of days. I'm saying, yes, Uncle, one of the
is a lawyer, he's a law lecturer and head of the law centers, second faculty of law.
Before that, petitioner's team, lawyers, had indicated that they had filed an application for a review of the court's ruling yesterday on the dismissal of the interrogatories. Well, the court took cognizance of that and retired into chambers to consider the issues that we had been ordered to all file. So at the end of the day, the court came back and read the memoranda of issues. 5 issues have been set down for the trial and determination of this petition. I'm confident that in the short course of time, you'll be apprised with the issues that have been set down. The court has also given an elaborate timetable for the hearing of the petition in strict conformity with the CI 99. So we are all supposed to be back on the 26th of January, that is Tuesday, this coming Tuesday, for the hearing of the petition to commence in earnest. It is instructive to let you all know that the 3 issues that we set down as our memorandum of issues have been incorporated largely in the issues set down by the court. Now, the court has also set down for legal arguments, a preliminary legal argument, whether or not the petition discloses any reasonable cause of action. Indeed, in second respondent's answer, that matter was raised by the second respondent's legal team as a matter which will be considered by the Supreme Court, and that has been set down for preliminary legal argument. When the decision and the rulings of the court was read, lead counsel for the petitioner raised the matter as to the filing of the application for review. But that was sharply responded to by Professor Ashi Kote, Justice of the Supreme Court. We all know as lawyers that the filing of an application for review does not operate as a stay of proceedings of the matter in court. Well, the return date for that application is tomorrow, the 15th. It's tomorrow. We will be in court tomorrow for that application to be heard. So yes, that is what transpired in court this morning. I don't understand what that submission is supposed to mean. They always are the first to make those submissions, but that submission has no place in law. As petitioners, they should have known that CI 99 governs these proceedings. And CI 99 has been in place since 2016. When did they realize about expedition, delay, and justice? Of course, expedition is justice. You don't come to court with a set of rules and you want to circumvent and obviate the rules by your own careless abandon. How do you come to court with a petition and you don't know that you have to file a witness statement? You don't know that you have to settle a memorandum of issues? I don't understand what is meant by sacrificing justice on the altar of expedition. Justice delayed is justice denied. So what is it? They are just not ready. It should tell all of you, they were advocating for a live broadcast of the proceedings. Not averse to it. Everybody sees what is happening in the Supreme Court. Every single day, lead counsel for the petitioner has one complaint on the other. You cannot blame the failure of a bad farm on your tools of implementation. Your farm is your farm, and it depends on how you cultivate it.
Angel.
So we should also not pander to this repeated rhetoric of sacrificing justice for expedition. It is the main reason that the election petition of 2013 delayed for 8 grueling months in court. Are they anticipating the same thing? I believe not.
This is Ghana's own Angel 102.9. This is Angel 102.9. Broadcasting live from the capital city, Accra. Angel 102.9. Broadcasting live from the capital city, Accra. Angel 102.9.
The Supreme Court is the determinant of its own rules. There are set rules governing the election petition. The application for review will be heard tomorrow. Whether they are successful or not is not left to me. I'm a trained lawyer, I'm not a clairvoyant. So what happens today will determine the course of the proceedings. Final question? Any more? Thank you. Thank you.
A lawyer for a war second respondent and another Danko Akufo-Addo. A formula who say more addressing press and temporary.
Please, it's okay.
Please, it's okay. Supreme Court of Honor. Any other? Almost please. I mean, please, it's okay. Very important. Please. It's okay. It's okay. Lawyers for the petitioner, and so more about addressing.
Right. Good morning. Counsel, thank you very much. Give us your reaction to the court's ruling today.
Well, we are quite shocked because we are here for pre-trial, for case management, and for those who've been in court, we know what case management is. Case management is a discussion between the parties and the court as to how the trial is going to proceed. Today, that's not what happened. We were told what is going to happen. There was no discussion as to what our views were on how the case should proceed. So we are quite shocked.
We understand tomorrow is the day you go come and argue your case out.
No, that's not the case. What the court said was that we file our witness statements by tomorrow, by 12 tomorrow. Now, that means we have just one day to prepare the witness statements. Now, you are all aware already that we had an application for interrogatories. We've served them with notice to admit facts. We've served them with notice to actually inspect documents. All those things have not been attended to. We have actually filed an application for review of their order yesterday relating to their refusal to grant us leave to serve the interrogatories. That has actually been fixed for the 28th. Now, all those things will have an impact on the kind of witness statement we will prepare and file. So if those issues have not been dealt with, those applications have not been dealt with, how do we file witness statements by close of business on the 21st? For us, it's shocking. It really doesn't make sense to us as lawyers who've been practicing in the courts for so many years. And we know what the rules are. We know what the rules are.
Counsel for the...
This is Ghana's own Angel 102.9.
And every objection that we've raised is grounded in law and is justified. I'm sure you are all witness to the arguments made by lead counsel yesterday. Did those arguments sound like they were just a ploy to delay the case? They were grounded in law. The fact that the petitioner has interrogatories to serve on the respondents. Now, interrogatories, as is stated, are to aid the trial of the case. And indeed, if a petitioner who has, or an applicant who has good grounds for serving interrogatories is denied the opportunity, for us that's a denial of justice.
In terms of the timelines that have been imposed, I mean, as it stands now, that is the timelines you all have to work with. I mean, is it something
Angel.
that able to meet, and in terms of your case, you are the
Broadcasting live from the capital city, Accra, Angel 102.9.
Now, let no one say we are not prepared. If we're not prepared, we wouldn't have come to court, we wouldn't have filed the petition in the first place. All we are saying is that processes we have served, processes we have filed, processes that need to be dealt with have not been dealt with. How do we start a trial? That is all we are saying. So if you ask us to come to court on the 26th to commence a trial, how are we going to start a trial when our notice to admit facts has not been dealt with? Our interrogatories, our application for review of interrogatories has been pushed to a date after the trial has started. I mean, it doesn't really make sense to us. Unfortunately, we have to say this.
Given your experience at the bar and with the experience of
This is Angel 102.9.
Yes.
And the position you are now in, do you think that the 42-day timeline is realistic enough for you to conduct an election petition?
Please note that under the rules, the schedule, there's 5 days for pre-trial. Today is the second day.
So what's the rush for?
So what is the rush? Today is the second day for pre-trial.
5 cases have been sent down for trial. What do you make of it?
Well, we are yet to, we are yet to be served the order. We are now going to look at, because it was just read to us. We need to now sit down and look at it. Did it, because we have also filed our memorandum of issues. Does it take care of all the issues we put before the court? Because that would have been the essence of case management. The parties going back and forth on the various issues they filed and the court bringing it together so that we are all agreed on the issues. That didn't happen. So we are now going to look at it to see whether it addresses the issues that we have raised in our memorandum.
Your colleague, Dr. Ayeni, was remanded by the court for certain gestures. What response to that?
Doc, you do that.
Doc apologized, and I think that should end it. He's a gentleman. I don't think he'll ever be deliberately rude to the court. The court took offense. He apologized, and that ends the matter. So thank you very much.
Baba Jamal.
Yes.
All right, Auntie. Hey.
You are dealing with your friend.
Yes.
Your friend.
Baba Jamal Bekasana. Auntie Obechim. So, when I can see you Baba Jamal.
Social media were for now.
But them person a friend not Supreme Court them.
Lawyers are how do I have from Supreme Court? They be crowd they can warm for crowd. And it is indeed they can't answer their cause because of where they are.
Baba Jamal. Baba Jamal.
To bring witnesses. All right, we had indicated,
Tofa or train.
Most likely. At the time.
Sure. Onya shase. Yanhwese yebenya ama ewo hɔ na afei yɛtiminya feeding it properly. We
broadcasting live from the capital city, Accra, Angel 102.9.
All right, so jeba check is yinya ama ewo hɔ na afei yɛtimina na kasa. Chairman bibi o hobio.
Oh, I'm say Senator no actually behwe say unse near lawyer review no entiase a lawyer for no press conference yi e de eba ene say em say am about so be church mu yi entiase a menya wo aye press conference mu e hye manager say echina e na court no e kwa akotena aye review chachuchi kata review na o de courtroom say court no ne nsem a enra obuaye editi a wono mo na be ya court na ansa nwene ho biom sa review no na there was contention on it say the review is normally ude asem court na asem no editi wa o send the court to be mu a no na efre bibi stay of execution na just say near court no share say ye bua masimesi we ye we no sa ne ma na ye hye no nyina no who holding on because asem no ye send the court to be and a stay of execution but a judge for this particular instance, you know, it cannot stay the trial or the case management process.
Yeah, the lawyer Ebenezer Ahiato.
Okay.
Or a constitutional lawyer.
Great.
Lawyer, good afternoon. Good morning.
Good morning.
Good morning.
Me patron to say.
Good.
Yen so yen ho ye pa. The course was Supreme Court in the Ubon Tofa Maya. Patron then I'll be trying womb.
Yo, Madam Master. Near course, and then no, your friend case management. Case management, which I said. Answer na yebedi asemno. This yebe starting hearing na obibe jina adakemu. Normally, no. As you say, you make sure of documents, witness statements. Bibia if asem no hu bia no. You be hwe ne yaka. Issues mo pese court no determine no. You be hwe sa nyoma ni nyina. Say your static case na enya pe na obi ebe kwa kofa bibi ni obi aba yemi. Nti eno no sa nyoma sa issues na court no ehwe kan na o hwe argument na a course na especially on the NDC side no na omo pese omunya more days because I saw omo file witness statement and here omo nyeye o sha no more argue say omo witnesses about 5 normally no case management no you be share witnesses you be share omo witness, omo evidence, witness statement, omo file. So any money no be check. But court number omo 26. So court na there omo we sit time omo be start omo hearing. Inti ni ati so obia ye bia na ati so make sure say on that date no obi bia wa file obi bia you ready because they will go ahead. Omo de be asem no. Inti no for now there you bet me aka technically no omo case management no. Until they are just waiting. More time. It say obi had the file, open file or witness statement. Go ahead and file. Until I feel na date ni be do na obi asa akoma same bia so we have to see a file we. Until na normal class and your money in every and.
Tisa enema enuma Supreme Court President no reading it out no. Yan fan say ekoba say echina na say some file on witness statement no be nipa be enum de no wo mo antimi anya den e be si.
Some of the judges at times it depends on the judge. What's your practice? I also near court all the time. Yes, if file it. That's a one file here. The court to go ahead. If you are no more, you bet dismiss your case. Normal go ahead because the other normally we a petitioner who a wow case and nipa now then a court so cross petition what you say say or no na you declare so or no na we winning. Into no yes file statement witness statement no one file here. We are lucky here. Court no ba obey to me apply for extension of time within which to file. We are lucky on the grant amount. One year lucky so they will go ahead without you. Into witness statement here, you find the agro. Who did the agro? Some of the judges they've already given you the go ahead to do it. 1 year within that time, one share over accused will be said on yet, but some of them that is the way they are. You will proceed with the case without you.
Review na ebe koso echina no efa the chachua file efa interrogatories no ho a court no ebotugu ye no enchechire mu ne sen.
Interrogatories processor work court file. Normally so filing interrogatories some of the questions will be answered. During the trial itself it will be reduced, especially when it comes to cross-examination. Questions bianca, it is obisani adienina interrogatories will be answered. Now, a issue of discretion, and this is so important. A issue of discretion.
But what kind of issue of discretion? No, actually saying what I remember.
Discretion, actually say. Judge, and he be decided say. Obe grant ya non grant.
Yes, sir. Said you're not doing a no.
Sir. Na ye nimunsu says who use discretion and you're in a vacuum. I mean, it's subject to so many things. But the most important thing is that judge said they are not doing no and obe granted. Until no, ube to me a file normally ube seeking leave and so now. Judge na go ahead. Until no, file is up to him. Or no, all your case, no. It's your face, yeah. Questions, no, bet me reserve those questions during cross-examination. Bet me beside those questions. Now, when you answer, bet me I can see there. Oh, and your my way, no, if you are no more, the idea is that your person case may be delayed. But who been so argument, and said, no, I have to go ahead with it. Until at the end, the judge will determine, say, okay, let me allow it. And now let me refuse it. Enti near petitioner not legal team omo de buyer no omo refuse ye and run omo grant amount, but they've asked for a review. Enti na nra obekaya omo lead counsel he was asking for not okacho omo say omo here a copy of the court ruling on it. Say they have gotten it into no omo apply for a review of the decision. Until now, again, it's subject to the court. You need to be. just omu decide answer na ye hu ne a ebesi ewo ho.
Okay, me say we need Supreme Court ho there, but echna de no so on betna se ayent say de wo mu ye ne ya na se eno no de e bia emma public domain ma ye ntimi nyanhwe.
Echna no o hwe ya o ma o deadline echna so mo file o witness statement. O hwe CI 99 na up to 5 days for case management. Ain't no minimum ye best there, but possible. All say normally no o file witness statement na over several the other parts. Now on so several ne there. Ain't it so omo go through witness statement no more agree. Say okay, witness statement no. Yeah, we are not opposing anything. If a paragraph we say yanjintum, this paragraph is a diatum. And you know, after filing of witness statement, it is all more yes, no more this statement will be added to. And she said, I'm a kind because you started case now, you started. And you feel that you ever share a witness statement, near our objective to witness statement, and your money now will go through near into the objection beer. That is the time where we raise objection to statement way, document way. Into the name it's not but what it is that we file a witness statement. Yeah, the court will not go ahead straight. Say yeah hearing. This say almost share witness statement. Normal look at all the issues I will raise. Say review a witness statement no more on the objective because you didn't plead it. Any petition, any answer to the petition, but you have introduced it. Lawyers know, yes, you have to go through. Now, when objection issues, I be raising objections. Now, case management stage, so raising no, resolve issues, answer na ya started. Case no said looking at time no in fact it may depending on time at some of the filing say almost filing in term be a several on term because you need time to go through your opponent's witness statement so there will be to raise the objection say best city depending on time best several each other with their respective witness statements.
Lawyer, I no pay that.
Yo, mentioning that was.
Lawyer Ebenezer Hiato, a constitutional lawyer, now to say no, ebo and common. Sechina review no. So I'm better not see a channel to say no muye dia, and the other chairman was a conversant in the nebium. Me I no pardon me by and said them yem jam them copem watch him in pem wasem. Pem wasem cry. Them hear me who find with Courtroom hon. Better hadin. And them see a peme sano. Or him be a him fee or him kasi be pan a him fee na chame hene. The beer ye dear seven. Oh no, don't to be back on my chamber 5. Hey, or Tmusa on Penecom. I do yan oh, I'm sure. Oh, I'm sure. I'm sure. I'm so kakra. Ade ya koso saa. Da kro no hen ka se da bi. Enne pa e bo no nan a. So ba bi. Mon ko no hon na mon ko frɛ ne se me se omra. E bo no nan ya yedru ye de atitim. Tim. Se na chame hene ba. Oh ye no hu ye pa. Why was ampa match bi
Yeah.
Nah. What down, dear court no free former deputy attorney general. Share the says I and why back on that or some pre no money ye biumuno. What down my actually saying?
Former deputy what they say is it what they say
Dominic Ayeni. Meaning so no can so repeat it. Na judges no kasem na chachu jina o kasa na judges no e ka bibi e che chachu em say no so ne lawyer foforo e din komo
he has been showing some gestures
showing some gestures
I
will court to home president of the Supreme Court ne catch them say or ye bi na no man catch them say onyai and then so why you bium now for the respect of woman intino or catch and says adie no e man nye bium e ba na sa ya na ehu ana
minya eyifu won say ye kokota judges no the whole courtroom any obi biara obi ano come under their jurisdiction and you have to comport yourself. There are do's and don'ts in the courtroom and can among members of the bar, because when you're a member of the bar, you are an officer of the court. So the court is very critical as to how you conduct yourself. You see, you can communicate through three ways, either through writing or through oral or through body language. So when your body language is communicating something to the bench and they feel that language is trying to undermine their authority and now expose them to publicly to the critical or to create an impression as if you are not in agreement with them, they can reprimand you. And then what has happened is reprimand. And if it's coming from the president, there are two things he can do to you. Either he will place a ban on you from coming to the courtroom, or he can be cited for contempt of court.
Hey, yes,
it's true. Let's say happen maybe and from coming to the court. Yes, by your conduct.
Court one I
yes, you see, we if you say under Article 125 of the Constitution now. So see, justice emanates from the people and shall be administered in the name of the people by the judiciary. And the same constitution talks about the judiciary exercising final judicial power. And so what happened is that this idea of contempt is to ensure say the court are respected, the court dignity is protected, and then people go to the court with some amount of respect. I say like the judges represent God on earth. And you call a minima. They say do time with some reverence. So the moment you appear before judges, especially the highest court of the land, you must go there with some kind of decorum in terms of even you don't treat children. Yes, contempt of court. So to court now, yes.
Me take court one. Maybe me person me bro be a few. Me we me gam no so and also so contemptuous.
Yeah, we say it be gam na tatra. Maybe gam be you out to be no show no be. Na go say odipa kwa say no kan ya. So baby I would be that.
Asa wa say enye titra kura na wano no chia kakra. Asa asem na judge ni busa kwa me na ye wa
good.
Hey,
what I say? It's so the judges have what it takes to interpret all these things. And you know when you go to court, you find here in court. Now when I say clack, you are disturbing the court. What I say? And then you go court and you could do what I say? Want to be courtroom now we start where what I say, courtroom, and now courtroom one and judge, we should now. I say, we do the chibi. What I say, either say, man, I be. What all those things are contempt of court.
Hey, let's say you want anybody prepare that one not one anybody say prepare.
What say, your eye contact be a send a lot of signal. What say, about your eye contact be a bit my year. Now I say, yes, to be the strategy, what I say, what the strategy, and now I put a new eyes like shadow shred. All these things, they look at all those things because all them say people communicate through body language. So they read body language, and then when your body language is not proper, they'll be dealt with.
Now, say, be a me to court, be a me call night. Now, my case case. Now, Quatona, Wana, Watunko, Kakram. Wow, no, that, and also,
and then the contempt. Oh, the pa, you to be catch yourself, my friend. Oh, that. It is sorry. Now, Kojina, Honebia, and an intim call. You shall not say how die. You catch yourself, Kofi. You catch yourself, Kofi. I don't know what is over there.
Rest in peace. Rest in peace. Go home and rest in peace.
Let's go. Okay. So look at 2013. Oh, no, I've been Okoye. No, I'm a Kubia.
Okoye, no.
The Casa confirmed the case.
And yes, Senanu.
Senanu, Yari. Senanu, Yari. No, Yari. Into Ottawa na Casada.
Ottawa?
Yes. Ottawa na Casada. Order. Into your for the case, only say for the case. Your board. The from amicus.
Okay.
Who can say amicus do finally say shoots no one unconstitutional. But lawyer say we don't need or say finally on behalf of 40 voters.
Aye. Yes.
Or say he wants 40 voters to join. And finally for joining the Supreme Court for catching this and now 40 voters no they don't have any interest in the matter. What they say that time order. Until what point you to say judges will man one can about or can say and then the fourth.
Asemo. Now review no utie Mami Marita Brewer na chese ebeba switchna.
Good. And to know, I think say we watch the attitude of the court now. They are having in mind the 42 days, and they want to resist or make the time. I think that the heading now Makano a review a very difficult application because you are applying before the same judges are. They made a ruling chair, and so you must demonstrate exceptional circumstances. You must tell them that my lord. With the moment judgment, no, we feel no way, and that law too is binding on you. And then number two, now facts we will feel say, now one all these are matters I say to me, a confusing question, and stand a crown, Yama Quina, why you review. Into the woman say, Ochinano, Uber who said Americano, Ayamra. The first thing that they will tell them is to convince them what are the circumstances. I am finally review no. If you don't, they throw you out.
Oh, and you know, say the say bia obi wo exceptional things be an refi say bia chachu will be exceptional. Lobby and so court na wentimi an be an refi no ba kwa kai ne ade a ebetimi ama judges na won kasa dismiss say unanimously won dismiss case no ebetimi afri the etimi asan ko bekum say oh we do we abeka ho de masesa madwen.
You see I say to me demonstrate say judges no decision no man taking into consideration a provision in the constitution. I am the highest of the land. You see, every judge is bound by the constitution. Until to make that so, my lord, judgment is contrary to this constitutional provision. And to know a mistake because a man is not a conflict with the constitution. And I will share law also. We share I take a 1, 2 now. Every law or judgment, anything that a conflict with the constitution and null and void. It would be raising that legal objection. Judges and now, my lord, there is so much crucial information be one and somebody my court. But at the time, may argue case not any ready, demonstrating why how are any ready yet. What I said, and now fresh evidence thereby, fresh fact thereby, who the become one, it changed the whole complex. And that is what your duty judicial review. Because without that, no, Judge Rebecca said we are just trying to delay time. So they will just throw it out. And do what I'll call Supreme Court review. So they will review 10. And there 1 or 2 people pay to society. All lawyers feel it because most review, no, it's so easy to overturn a decision of the Supreme Court because they don't want to be seen as if they are there and they are committing mistake. So judges hardly grant review.
Review, but I had impended saying.
Oh, Bakope.
We a pim.
Nap him into could be BAPU. Yes, so you appeal to heaven.
Maybe some lawyer here toss to say,
you,
sir, court now catch counsel for the petitioners, and say, omo modiana omo file omo witness statement. Now omo indicated to the court say omo wo nipa beye enum adasefo beye enum a ombe frɛ omo. Now omo modina omo file no echina before 9:30 a.m. Now Adentina ya na court no more time account say yes me filing before 9:30. Na say me ko file no 10:50 a metie bibia na.
Yeah, normally the be man say uhwe say by 9:30 no untumi file a I say bomodia na file application for extension of time, meaning beba before the court. What the court say, my lord, share me say me file 9:30 a.m. But unfortunately, no, me here because now my reason reasonable, so to be convinced you. Now who say in fact we be but when to me in the be oh sick say be steady time not to be area and the following day. So that's what we do. The moment we want to now comply with the orders of the court in terms of time, you must come and seek extension of time.
Wow. Lawyer me fa wonsia e kire dey be share wa fidie so na yet me abokomo lawyer Dr. Morris Apau na what is say no bokomo chama say bibia ne o
David MCC dey adofo na beda omo ase kankan ne omo omo support yen na beda omo ase ne tia so
abofunfo so you
correct. Mr. Yabre nti yekope adonko next level energy drink na ye dey one so adai e be correct pa unya bia no so enya bad crowd na Emphasis the case so Emma Ines Fly bed back solution for a cat bed back solution now we so crunchu and yede ho anuyi e de abre was na be betu ase if you feel hotel school compound ne school dormitories ne ade ni nyana no ohia Ines Fly bed back solution eno ya ye ne se eye nso ntie bogu eye dem ho na kona ntokro bia wotimi abobobo na akohyehye tumi rewrem sa ne nso crunchu a wose wono na so odin bia no boa se bed Ines Fly sa nso yi bora hono a kodwo to mawansa enka bi opedodo etu aton na opa bi aton hu be bi akoto no ne ka kan opa hu nsam kan bia no afre telephone 0577 701 000 0577 701 000 sa anso so na Fido app bia aba FIDO Fido or Fido yesi opa bosia ewo mobile phone so na download sa app no de benya bosia nkola yi ebeko school nkola yi school ntade acheche wo mo mpabo asese ni school bag ni ade amodeko school here be 1000 bi 1005 bi now they are short na send them out aye Fido 4 app no ewo aye Google Play Store and as iOS Play Store betimi akọ no download aye Fido no FIDO or Fido or Fido o download eno no betimi sa transfer